Good morning, Counselor.
Good morning, Madam Clerk.
Why is everybody so low? Let me turn this up a little bit.
Can you hear me a little better now?
I think it's on this end, because I was messing with it yesterday. Say something, Mr. Cohen.
Good morning again.
All right, much better, thank you. I should say mic check. No. He's on Cato. Motion.
They played all day.
I don't practice, I just go to game.
Mr. Dixon?
Yes,
All right, I have you checked in. We're just waiting on your attorney, okay?
no problem. Thank you.
All right, do you have video?
Yeah,
All right, you're gonna need to turn your video. You can put your device on mute until we call your case. All right. That's perfect. Thank you. So I had the motion hearing ready, Judge. I don't know if you were ready for that. Yeah, it's actually.
36th District Court, City of Detroit, State of Michigan is now in session with the Honorable Judge Ronald Giles presiding. Here you go.
Yes.
Oh, okay.
Oh, yeah.
Calling case number 2357639, the people of the state of Michigan versus Mac Cato. Defendant is charged with count 1, assault with intent to murder, count 2, assault with intent to do great bodily harm, less than murder or by strangulation, count 3, assault with a dangerous weapon, felonious assault, count 4, count 5, weapons felony firearm, count 6, weapons felony firearm, habitual offender, second notice. This matter is here on a motion hearing.
Good morning, Your Honor. Adam Booker appearing on behalf of the people, P86266.
Good morning, Your Honor. Neighborhood Defender Service by Jonathan Cohen, P86151, appearing by Zoom. Mr. Cato is in the Wayne County Jail, but I think for today's purposes, I'm willing to waive his appearance if the court is.
Okay, we'll waive his appearance for the purpose of today's hearing. All right, this is that's the discovery order.
Yes, Judge.
Go through them line by line, see which ones you have issue with.
Sure. Does the court have a copy of it that I can see? I believe there were two main copies or two main issues that my office had with it. Specifically, Your Honor, the people would object to line 4A and line 4D. Specifically for 4A, the names and addresses of, well, there, as far as I know, there's no expert witnesses. So that's one thing. But for the lay witnesses, Your Honor, I believe my colleague and supervisor, Lauren Arsesian, sending a protective order. If we're going to turn over the victim's personal information like their address, the people would just request that a protective order was signed so that that information cannot be shared with third parties or the defendant himself. Specifically for D, Your Honor, obviously with lien records, specifically for the defendant, I can't turn over lien records. The Michigan Supreme Court, people we Koja 658 Northwest 2nd 153 vacated the Court of Appeals opinion saying and citing the dissent, stating that that information does not be turned over as by statute. Specifically, Your Honor, people would cite MPL 28.214 that says by statute, lien information may not be given to a private person for any purpose. Doing so is a criminal offense. So I'd be committing a felony myself if I turned over any lien information. Further, I don't have any lien information or the criminal records of the witness in this case. And under People v. Leo 188 Mich. App 417, the court stated that the prosecutor's office is not required to undertake discovery for the defense. So I don't have to go out and get that information from Mr. Cohen or his office. So those are the main objections that people have. We have no objection to turning over the unredacted discovery. We understand that there's recent court cases that say we are, the defense is permitted to ask for that and that we have a duty to turn it over. We would just ask that before we do, the court would sign the protective order to protect the witnesses, especially in a case that's assaultive in nature like this one.
Thank you, Your Honor. My motion is based, I think, 100% on the Michigan rules of court, specifically Rule 6.201, that pertains to discovery, both subsection A and subsection B. This is a standard form request.
No, it's not a form. Scale provides standard forms. This is not a scale form. So there's nothing standard about asking for the name and addresses of all lay and expert witnesses.
I apologize, Your Honor. I did not mean to imply that it was standard in the sense that the Supreme Court had authorized it or that it is. It's certainly not on a scale form. I meant standard sort of for my purposes. This is the same motion that I submit in many cases, and it is based on the language in Rule 6.201, specifically subsection A1 says mandatory disclosure, a party upon request must provide, quote, the names and addresses of all lay and expert witnesses whom the party may call at trial. And so that's the basis for that request. With respect to the criminal records, both of my client as well as witnesses that may testify, again, that is found as mandatory disclosure under Rule 6.201, subsection 4. Any criminal record the party may use, and subsection 5, a description or list of criminal convictions known to the prosecuting attorney of any witnesses whom the party may call at trial. So those are the bases for that request. With respect to the request for the protective order, it's my understanding of current case law that the people would need to provide specific reasons in this particular case why a protective order would be appropriate or necessary to protect the identities or to protect, to protect the safety of the witnesses in this case. So, Your Honor, I believe that there is a showing more than just saying this is an assaultive case. The case I would cite to is People v. Antaramian, that's ANTARAMIAN, M as in Nancy, excuse me, M as in Mary, I, A, N as in Nancy. It's a very recent case that only has a Westlaw site, 2023 Westlaw 3397440 from May of 2023, which I believe indicates that there must be a showing above. Sorry.
Hold on. Are you saying that this case has already set a precedence by the Court of Appeals? Because if it doesn't, I don't have to listen to it at all.
Your
I don't
Honor,
care what any odd case says from any odd place. It doesn't matter. I only have to follow the ones that I'm required to follow.
at a bare minimum, Your Honor, I'm citing to it as persuasive authority.
To hear it, because it's not.
Again, Your Honor, my understanding of current case law is that something more than what every case involves, in other words, the general risks in any criminal case involving assaultive allegations, is required from the prosecutor prior to redacting, or sorry, prior to it being appropriate for information to be redacted, or prior to a protective order to be issued. So if no such showing has been made, which I would argue there hasn't been, I would object to the issuance of a protective order.
All right, there you go.
Yes, Your Honors. Yeah, I won't belabor the point, but specifically as this case with the protective order, I mean, I'm reading the first page of the investigative report. Essentially, the shooting seems to have happened by in a car, so it wasn't at the victim's address or anything. So I would argue that in this case, you know, a protective order would protect the witness's private information that the defendant may not already know. It's really just for the protection of the witness as we go through this process. I don't necessarily see why the address is relevant anyway, but I don't think a protective order is too much to ask for in this case in order to turn that information over.
All right. As to 4A and the name and addresses of all lay and extra witnesses, well, why not? There are no extra witnesses in this case. As to the lay address, I'm going to deny that unless a protective order is presented that would limit the access of that information to any other person other than yourself, Mr. Cohen. As to D, the accurate copy of the criminal record, I'm just going to deny it. I'm not going to allow it on. You have other ways of receiving that information. Your client knows his criminal record. He should be able to tell you. And as to the criminal record, any prosecution witness, you're only allowed to get certain information. And that is one specific question that you're allowed at exam or trial or during any kind of hearing, which is whether or not they have in the last 10 years any criminal conviction dealing with theft or dishonesty. That's the only thing I'm going to allow. So that's the court's rulings. I'll take it from there.
Thank you.
Understood. Thank you, Your Honor.
But at this point, what I will do, I'm going to cross those two out. I'm going to initial off on them. Then I'm assigning a discovery order. So the rest of it is good. All right.
Thank you.
And you can present the order, protective order, and then that other information will be given to you.
Very good. And I believe we're already set for examination.
Yep.
Okay. Thank you. There's nothing further from defense.
All right. Thank you.
Nothing from the people. Your Honor.
All right. That'll conclude the hearing. Thank you very much.
Thank you, Your Honor. Have a good day, everyone.
You too.
Good morning, Mr. McRipley.
morning, how are you? Mr.
Good, how
Jimerson?
are you?
Okay,
Yeah, your client is on. Are you ready?
ma'am.
Calling case number 21-56362, the people of the state of Michigan versus Jaquan Dixon. Defendant is charged with count 1, police officer fleeing, third-degree vehicle code, habitual offender, second notice. This matter is scheduled for a probable cause conference.
Good morning, Your Honor. Adam Booklet here on behalf of the people, T8626.
Good morning, Judge Giles. G. Whitney McRipley on behalf of Mr. Dixon, who's present on Zoom.
Mr. Dixon, can you state your name for the record, please?
Good morning. My name is Quan Dixon.
Thank you. Mr. Dixon, just so you'll know in the future, I don't do t-shirts or sweats in my courtroom, even on Zoom. So next time you come to court, please wear a shirt with a collar, all right? You don't have to do anything now, just the
Oh,
next
yes, sir.
time.
Yes, sir.
All right, thank you. All right, Mr. McRipley.
I need an exam date, Your Honor.
All right, you're available, July 17th at 10:15.
No, Your Honor. Can we do the next date, 18?
July 18th at 10:15.
That's fine.
All right. All right, anything else?
No, Your Honor. Now on behalf of defense.
And nothing from the people. Thank you.
All right, that'll conclude the hearing. Mr. Dixon, that's an in-court hearing. So we'll be in courtroom 233.
So, all right. So come to 36th District, courtroom 233.
Yes, sir.
All right. Is there any way I could talk to my lawyer?
Sure, we can put you in a breakout room. Just gotta accept the invitation to the breakout room and you can talk to them privately.
All right, thank you, Your Honor. Have a good day.
You too. Take care now.
I didn't mean it to come back, but I think with the prosecutor could make sure I get this discovery on this. That's a refile, but I need to recreate my file.
Of course, Mr. McRipley, I'm actually looking into finding it myself, so I'll send it to you as soon as I find it.
Okay, thanks a lot.
Yeah, of course. See you later.
Calling case number 23-57531, the people of the state of Michigan versus Ron Moore. Defendant is charged with count 1, assault with intent to murder, count 2, assault with intent to do great bodily harm, less than murder or by strangulation, count 3, count 4, assault with a dangerous weapon, felonious assault. This matter is scheduled for exam.
Good morning, Your Honor. Item book appearing on behalf of people P 86266.
Good morning, may it please this most honorable court, Raina Mitchell appearing on behalf of Mr. Ron Moore, who's standing to my right. Please state your name for the record.
Ron Moore.
Your Honor, today is the date, time for the preliminary examination, and we're ready to proceed for the defense.
Your Honor, the people are not ready. I did ask the court for an extra 15 minutes. We did call Mr. Frederick Davis to check if he was coming to court. He told us he was. He would be there by 9:15. Court was kind enough to give us 3 extra minutes. It's now 9:18. Neither Frederick Davis nor Evan Kane are here. People aren't able to proceed.
At this time, Your Honor, we're asking for dismissal.
Matter dismissed without prejudice.
Thank you so much, Your Honor. And I'll bring you the form so you can. When is your birthday?
January 12th, 1987.
Yeah, wait outside your paperwork.
Okay, wait.
Or still your phone. Do you want him to sign as well?
Yeah. You could-
Yeah, you have to sign it. Because it wasn't. It wasn't.
You guys have a short docket today.
Yeah.
Like, thank God. Is that a silver charger?
Yeah.
Don't you love it? I love my charger. I carry it like a baby with me everywhere.
Yeah, I do too.
It's a great charger. I've ever had. I'm like, I know that charger.
Yeah.
And it's so small on both ends, so
Yeah.
people don't have that.
So you can't.
know that's yours.
Yeah.
My husband, he was like, why you get that? You just-
Because you
But
can't
now
share
he
it.
be asking.
Yeah. Because
Where
they
you
charge.
charging at?
It's awesome.
No, yeah, I love it. Oh. I mean, the likeliness of everybody in the world.
Yeah, you.
I just can't.
Yeah, now that's a good idea. That's a good idea.
Maybe I'll do it this evening.
I would do that.
I'm
instead of-
gonna stop at the gas station and do it.
Oh.
That's it,
Story I heard.
That's it. I know, I think I told you I was. After I had. I was surprised.
They look like they think she left the scene or something, you know, what they thought, but they're saying this is the Yeah, a lot of them older people, a lot of these diseases, the COVID coming in and stuff, you know, it's health wise, right, the time to just. But it's just devastating, but it's like, it's like he never thought life was on. Talking shit about it, like in his voice, you know.
Ty,
Yes, ma'am.
leave room. I got Miss Barrett on for, Ewing.
What time?
Yeah, I called her. She said she was trying to locate what courtroom. So Judge, Mr. Ewing, I don't know. I got a jail list saying he's in jail. But he logged in yesterday on Zoom and I told him to log back in today. So I don't know if he got released early. And then, I don't know, they put a law, he was still in jail, I don't know. Oh, it's good.
No, on my standard.
Oh, that's a lot of underline.
I know. I know.
His objections are underlined, Judge.
We just argued these.
So set it for a hearing. All right, we're gonna set it for a hearing. I forgot what court date.
You know, deep recovery is a lot.
I mean.
Oh, maybe that's Mr. Ewing.
I had to make it to court.
Right.
Right, he does what it is.
Oh, hold on.
He called Uber, he ain't trying to.
Oh, he is in jail. Miss Barrett?
That's why he probably.
Yes.
Okay, he's in Wayne County Jail. I'm putting him in the, courtroom now.
Okay.
Who's the Peter? Who is that? I don't know who that is. That's the wrong courtroom on that one. Good morning, Wayne County Jail. Where'd you go? What happened? Where'd they go? Good morning, Wayne County Jail. Like they're on, but they can't. Good morning, Wayne County Jail.
I have a question because I was having problems with location too. Is there any way we could just adjourn the PCC so I can have an opportunity to talk to him?
Well, adjourn them, Ms. Barrett, we'll set it for an exam. Got more than enough time to talk to them.
Okay.
Let me see if I can. Hey, Ty. Do you have a number for Wayne County Jail?
Yeah. They don't
Isn't
like
it
that.
224?
They probably won't bring them on because they don't like that.
But, but they're saying there, look, Wayne County Jail.
Which number you want, video?
Yeah.
224-7839.
It's showing they're on, but it's
You might,
saying
you
that.
know, it could be that they run earlier than because they couldn't find.
They weren't in the waiting room early. Good morning, how are you? Yeah, this is Kitty Giles, courtroom 233. So I have Wayne County Jail for, Derek, we have a Derek Union that's in jail. Okay, so it showed, okay. So it showed that you guys were in the waiting room. I let you in, but I can't hear nobody.
There it is.
Oh, there we are.
There it is.
Okay, let me find out who this is. All right, thank you. Wayne County Jail. Who is that? Who is that?
Michael LaPinta.
Okay, I don't have him on Judge Giles' docket for today. I have a Derek Ewing.
Oh, no, it's the wrong courtroom. I'm sorry.
Are you gonna bring Ewing out? Oh, no, they said.
Ewing. Mr. Ewing is at Third Circuit right now, so he probably won't make it today.
Oh, okay. All right, thank you.
No problem.
So he is in jail. All right. You ready, Councilman? Calling case number 23-57659, the people of the state of Michigan versus Derek Ewing. Defendant is charged with count 1, police officer assaulting, resisting, obstructing. This matter is scheduled for a probable cause conference.
Good morning, Your Honor. Adam Booth appearing on behalf of people, P86266.
Ms. Barrett, your appearance, please.
Good morning, Melita Baird on behalf of Mr. Ewing.
Barrett, I do these at 8:30, please, all right?
Yes, I apologize.
Thank you.
Trying to
All right, your client's in Wayne County Jail, and right now he's at Third Circuit Court. So
Okay,
you'll be able to get him at the Wayne County Jail.
okay. So do we get a new PC or preliminary exam?
I'll give you an exam date.
Okay.
Okay. July 18th at 10:30. Is that
Okay,
good?
that's fine. That's fine.
Okay.
All right, thank you. Have a good day.
You too now. Thank you.
Thank you.
Bye-bye.
Bye.
Yeah, that's it too. Ty, can you get?
It's over here.
Oh, it's okay. Calling case number 23-57386, the people of the state of Michigan versus Totez Drew. Defendant is charged with count 1, assault with a dangerous weapon, felonious assault. This matter is scheduled for exam.
Philip Henderson on behalf of the people, P86029. Good morning, Judge Giles. Good morning to your staff, Neighborhood Defender Service, Carrie Martin, 84592. Hearing on behalf of Mr. Totez Drew, who stands to my right. Mr. Drew, state your full name.
Thank you. Ready to proceed?
Yes, Your Honor.
Your first one?
Your Honor, the state calls Mr. Brian Metry to the stand. He's a civilian witness.
Ready, sir? Can you right? You swear or affirm that you truth, anything the truth, self, you got.
Yes, I do.
You put a door towards you. All right, Mr. Metry. You're going to ask a series of questions. First by the prosecutor. The defense attorney will probably ask you questions. I may or may not ask you questions.
Okay.
All right, you have to answer all your questions out loud, verbally, using words. Just can't shake your head and say, you say yes, no, whatever the answer is. All right?
Yes.
Also, when you are asked a question, I need you to listen to the question, just answer it and stop. So if it's a yes or no type question, just say yes or no. If they need additional information, they'll just ask you another question. All right?
Okay.
We all have a tendency when we want to talk about something, especially if it's been somewhat traumatic, we tend to ramble.
Yeah.
You know, we'll say this happened and this happened, because we want to get the whole story out.
Yeah.
All right. If you do that, I'm gonna miss something. If I miss something, I might not make the right decision. All right.
Okay.
I know nothing about this case.
Sure.
Only thing I know about this case is the defendant's name and what he's charged with. And now I know your name. I get all my information from what happens in court, one question, one answer at a time. That way I can understand what happened.
Okay.
All right. Thank you, sir.
Thank you.
Proceed.
Could you introduce yourself to the court, sir?
Yes, my name is Brian Metry.
And Mr. Metry, did something happen on October 10th, 2022 that brought you here to court today?
Yes.
You know, where was that at?
At my building on Mack Avenue at 15433 Mack.
Is that in City of Detroit, City of Wayne?
That's correct.
And
Well,
How-
wait. You said City of Wayne. Is this Wayne or Detroit?
Detroit.
It's Detroit.
Wayne County.
Okay. All right, just want to make sure. Go ahead.
and how did that begin? You said there was something that brought you here to court today. How did that begin?
On that day or prior
Yes,
to that?
on that day.
I was actually working out of the back of my truck on the side of the building on the Nottingham side. My truck was parked. I was working out of it, fixing a door that the defendant had broken the day before.
Okay, and while you were fixing that door, what, if anything, did you see or hear?
Well, the defendant came up to me and started running his mouth, yelling, "I heard you accuse me of breaking your door." I said, "Yeah, I know you did it." And he basically said he's gonna kick my ass, he's gonna bitch slap me, and he said, "I'll be right back." He had his baby in his hand and he took his baby out to the front
Okay, when you say the front of the building, or what do you mean?
Yeah, I'm parked on the Nottingham side. It's on the corner of Mac and Nottingham. So
Okay,
he went up to the front of the building on Mac. And I wasn't watching him, so I don't know where he put the baby. But he came back without the baby. And,
when he came back, what was his demeanor?
oh, he was angry, yelling, acting like a bulldog,
What was he
threatening
yelling?
me.
What was he yelling specifically?
I'm gonna kick your ass, I'm gonna bitch slap you, you effing N-word.
Okay, and what did you notice anything about his appearance or his what was he doing? What was
He was angry, he was determined to kill me like he said he was. I mean, he came at me hard and started, then threw a punch at me, so I'm trying to defend myself and, I got my fists up and, he's swinging, I'm swinging.
Did he at any time make contact with you with his fist?
Yeah, we were near a parking block on the side and I was kind of falling over that parking block and I think I ripped his shirt and he punched me in the forehead and, I got scrapes on my knee and I got a big knot on my forehead from him punching me and.
Okay, so where were you at when he punched you?
Close to my car on the side of the building on the Nottingham side. There was a parking block that I tripped over.
What happened after he punched you?
Well, as we got up, he went across the street. There's a landscaping business next door on the across Nottingham. I guess he found a brick over there and grabbed that brick and he started coming at me again, yelling, "I'm gonna kill you. I'll kill your dog."
Did you see the brick?
Absolutely.
Could you describe it for us?
It's just a red reclaimed brick or orange reclaimed brick,
And
full brick. He had it in his hand and he was running at me like a bulldog, threatening to kill me with it.
and what did you do?
I just started running around my truck to avoid him.
The person that you're saying was running at you with a brick threatening to kill you. Do you see them in the courtroom here today?
Yes, I do.
Could you point them out and identify them by an article of clothing that they're wearing?
He's in the checkered shirt right here.
Your Honor, if the record could reflect that he's identified the defendant in this case. Record, sorry. Nothing further to say.
Morning, Mr. Metry.
Good morning.
Two questions for you today.
Okay.
So you made this report, you called 911 on the day of these events you described, October the 10th, 2022.
Yes, sir.
And at the time you made the report, you did not know the name of the person who had had this physical altercation with you.
I did not know his name.
No. You'd seen him before?
Yes.
And fair to say that you had a negative opinion of him by that time?
Sure. Yes.
Yes, it's true that, when officers came, you described this person to them as, quote, a derelict.
That's correct. I did.
And you knew this person's girlfriend, is that right?
She's my tenant.
Yes, what's her name?
China Johnson.
China Johnson. And you knew Miss Johnson's brother as well?
Not his name, but I knew of him.
Okay, so you were familiar with China Johnson, your tenant, and two different men who were involved in her life, both her brother and her boyfriend.
Yes.
And you'd had some landlord-tenant disputes with China, is that right?
Irrelevant.
Why is it relevant? Because it gets to motive.
No.
No.
Doesn't. Go to something else, please.
Two days prior, Ms. Johnson had made a complaint about the power being out in the apartment. Is
How
that
is any of
right?
this relevant? What does it have to do with your client being charged with assault with a dangerous weapon?
I'll move on.
Thank you.
So October the 10th, that was a Monday, correct?
I guess.
And you returned to the apartment. When was the last time you've been at the apartment?
Friday.
The Friday before. So then you get there and you say you're doing work on a door.
That's correct.
You noticed some damage to this door.
Door was beaten in.
So, and you claimed just now in your testimony that it was Mr. Drew who did this damage.
Yes, that's correct.
But to confirm, you did not see this damage occur.
I did not see him doing it, no.
You didn't see any footage of the damage.
I did not.
Okay, so was it your negative opinion of Mr. Drew that led you to believe that he was the one who had done this damage?
Objection,
No.
Your Honor, relevance.
This is now directly tied to what started this so-called fight. We're talking about the causing
Not what
event.
I have on the record, no. No, it's not. He didn't seek your client out. If he had sought your client out, then yes, I would agree with that. But he didn't seek your client out. You don't have anything on this record that said that this person sought your client out in regards to this.
So, Mr. Metri, you're standing outside by your car.
Correct.
Doing work, and you see Mr. Drew.
No, I didn't see him. I heard him coming at me like a bulldog yelling.
So you keep saying like a bulldog. What do you mean by like a bulldog?
Angry, vicious. Like he wants to hurt me. Like a rabid dog.
Okay, but he'd never hurt you before, is that right?
He's threatened me before.
Okay, he's never physically hurt you before, is that correct?
That's correct.
Okay. And so you start exchanging words with him, is that right? Before
That's correct.
physical. And what's the nature of that conversation?
He just said that heard I accused him of breaking the door, and he's gonna bitch slap me, and he's gonna kick my ass, and he's gonna kill my dog.
So when you say he heard you had accused him of breaking the door, do you know how he might have heard that?
I left a message with China Johnson.
What was that message?
I said, I know that you and your boyfriend broke into the basement and flipped the breaker. And I'm gonna press charges for vandalism.
Okay. So you had not seen Mr. Drew go into that basement breaker room, as you said. You did not see that happen.
I did not.
Okay. But something led you to believe it was him who had done it.
Well, the breaker was back on.
Okay, so.
And they stopped,
Wait, no. Okay. We get to the point, because right now, none of this is relevant.
Let me just confirm, Mr. Metri, you do have other tenants in that building, right?
none of which had a breaker
That's a
or a
yes or
reason
no
to.
question, sir. Yes or no, you got other tenants.
Yes.
Yes.
Thank you.
So you describe your injuries as a knot on your head and scrape on your leg. Is that right?
And I injured my hand.
And you injured your hand. And so we're talking, when you say there's a knot on your head, that's caused by a fist?
A fist.
Okay. And scrapes on your leg, that's caused by you tripping? during this interaction?
To avoid the defendant, yes.
And there's a scrape on your hand. Did that come from your hand making contact with him?
No, it came from me bracing myself as I fell.
Okay, so that was also,
And my hand's still not healed properly either.
your hand's not healed properly.
That's correct.
Did you receive medical treatment on the hand?
I didn't.
Okay, so your hand's not healed properly, but you never sought medical treatment?
I did not.
Did you ever seek medical treatment for any of these other injuries?
I did not.
Okay. Now, none of these injuries were the result of the brick, is that right?
That's correct.
The brick never made contact with your body?
No, it did not.
This brick was never thrown?
No.
Okay. And you had a dog with you at the time?
In my truck, he comes with me almost every day.
Okay, so, speaking about dogs, you're describing my client as a bulldog. What was your dog doing in the truck?
I don't know. I wasn't watching him, but he wasn't barking or anything. Wasn't making any noises.
Okay, and did you mention your dog at any point during your interaction with Mr. Drew?
No.
You made no mention of your dog?
No mention of my dog.
Okay. Did you have any mace or other type of self-defense spray or item on you?
I did.
You had mace on you?
Mm-hmm.
Was it visible?
Yes.
Okay. And did you touch it or reach for it at any point during this interaction?
I had it in my hand.
You had your mace in your hand?
Yes.
And you said that this tussle occurred close to your car?
Right, I was working right out of the back of the truck and he was right there.
Okay, so he's right there, you're right there, and your dog is right there as well?
No, my dog's in the front seat. I've got the tailgate down and I've got my tools in the back. He's in the cab of the truck up front. Doors are locked.
So I just mean, you're close to the dog. The dog's in the front seat of the car and this is happening around the car.
Pickup truck, not a car.
It's a pickup truck. I'm working out of the back, dog's in the front seat. Windows are rolled up.
So as you said, you never received medical treatment, you declined emergency medical services, EMS.
That's correct.
You didn't receive any therapy or psychological treatment after this happened?
How's any of this relevant?
Gets to,
It's not an element. It's not relevant. On to something else, please.
I have no further questions.
Thank you.
Briefly, Mr. Menchie, why did you run when the defendant had a brick? Why did you run away from it?
Because he threatened to kill me with it.
What were you thinking or feeling when you saw him with that brick?
I was shaking. I was, running for my life.
Thank you. I have nothing.
You recross.
No recross.
Thank you. You can step down. Thank you.
Thank you.
No, we have no further witnesses from the state. State restroom. No defense witnesses. Now, we have a motion for a bind over on the sole count of felonious assault. The defendant and the victim had an encounter where the defendant made several threats, including that he would kick the victim's ass, that he would kill him, that he would bitch slap him. So when the defendant grabbed the brick, it is a weapon which could be used to cause great bodily harm. He said that he was running away, he was running for his life. He was in fear that the defendant would make good on those threats, and he did identify the defendant as the one who did this. It identified that it happened in Wayne County. So we would motion for a bind over. Mike Calhoun.
Your Honor, when a felonious assault is done with an item that isn't inherently dangerous or inherently a weapon, It has to be used in a way that's likely to cause serious physical injury or death. That's what the criminal jury instruction states. We have testimony that a brick was held, but that this person, they were having a physical encounter, but no contact was ever made with the person with the brick, only that it was held in his hand. And we know that this person the complainant had mace, had a dog. I think they've not proven, even by a probable cause standard, that this brick was held for any reason other than self-protection. I don't think they've established that this inherent, normally non-dangerous item was used in a way likely to cause serious physical injury or death. You can take the complete lack of any injury caused by the brick as part of the evidence of that. So on that ground, I would object to the bind over of this charge. The people can refile this as a misdemeanor simple assault. I am not going to deny there's a prima facie case of that, but a felony with a brick, I would object to that.
Your Honor, in response, the defendant came back to the victim, or he came at him 3 times. First, the initial aggression, then he set his baby down, he came back, then he went and got the brick and came back. The victim described him as coming at him like a bulldog upon further questions. He said that it was vicious, the way that he was coming, that he was angry, that he was threatening to kill him. He was charging at him with a brick, and so that we believe that meets the standard for probable cause.
All right, court having heard the testimony, arguments presented as follows. On October 10th, 2022, Brian Mary Petrie, Brian Petrie was at 15433 Mac Avenue, City of Detroit. This is a type of apartment complex. He was fixing a door that had been broken the day before. Defendant came up to him, started arguing, started to kick his ass, fist slap him. He had his baby in his arms. Then walked away and took his baby out of the witness's view. He came back at him swearing. First he began telling me about kick his ass, fist slap him, threw a punch and hit him. We both started to hit each other or swinging at each other. That stopped. Then left, went across the street, came back with a brick, saying he was going to kill him and kill his dog. Witness had to run around the truck because he was in fear of his life of being struck. That is all that is necessary for a felony or felonious assault. Court finds that the felony enumerating the complaining warrant did in fact occur in the city of Detroit. Probable cause is discharged to be found over the Wayne County Circuit Court Criminal Division for arraignment on the information. This was July 25th at 9 o'clock. Coach.
Thank you, Judge. Thank you.
Can you approach?
Yeah.
You ready?
Yes.
Calling case number 23-57545, the people of the state of Michigan versus Xavier Barragon. Defendant is charged with count 1, assault with a dangerous weapon, felonious assault. Count 2, weapons, felony firearm. This matter is scheduled for exam.
Good morning, Your Honor. Item book appearing on behalf of the people, P 86266.
Good morning, Your Honor. Neighborhood Defender Service by Jonathan Cohen, P 86151, appearing in person with Mr. Xavier Barragon, present and out of custody. Mr. Barragon, can you please state your name?
Xavier Miguel Bergen.
Thank you.
Your Honor, today we are proposing to waive the right to a preliminary examination in this matter.
The people have no objection, Your Honor.
All right, thank you. Marion, you understand that you have a statutory right to a preliminary exam where the state must show by probable cause a crime was committed, and by probable cause you had something to do with committing that crime. You understand that?
I understand.
Anybody promise you anything or threaten you in any way, get you to waive your right to preliminary exam?
No, sir.
You're waiving your right freely and voluntarily after having opportunity to talk to your attorney about it.
Asking if you're waiving freely and voluntarily after talking to this is for you, so you're on free will.
Yes.
All right. You signed the waiver of examination form, sir?
Yes.
All right. Court will find that you freely and voluntarily waive your right to preliminary exam and filed over the Wayne County Circuit Court Criminal Division for further proceedings. The arraignment on the information will be July 25th, 2023 at 9 o'clock p.m.
Thank you, Judge.
Thank you, Your Honor.
Thank you.
Yeah,
All right, take care then.